Senator from Utah.
Mr. President, I appreciate the care, attention, and detail shown by my friend and colleague, the distinguished senior senator from North Carolina. I do disagree with him for 10 independent reasons. Number one, as to the suggestion that the proponent of the unanimous consent request now before this body, that is the very simple, clean reauthorization of the expiring provisions for 45 days, giving the Senate an opportunity to spend just a few weeks to debate and consider these amendments after dealing with the coronavirus crisis. He suggested that I, as the proponent of this measure, have, I think the words were, never supported any of these tools. Never in my entire time in the Senate lifted a finger to support these tools. That's curious, because I was the author and lead sponsor of the USA Freedom Act, which in 2015 extended and reauthorized these very same provisions. So his first argument is factually incorrect. Secondly, he points to the lone wolf and roving wiretap provisions as things that he's concerned about. I understand that. They want those. Now, lone wolf isn't used, but it's sort of a security blanket. People like knowing that it's there within the government, and I'm willing to let that go. Roving wiretaps, it is used from time to time. I'm willing to let that go. In fact, I've offered repeatedly, I'll offer again right now if it's helpful. I'm willing to reauthorize those right now without a single modification, without a single limit beyond what's already been put in for the other provisions. I'm willing to do that free of charge on anything. So those arguments are, frankly, disingenuous. Number three, the suggestion that I'm somehow holding this bill hostage. You, sir, have it wrong. You have it precisely backwards. What I'm doing is saying let's preserve the status quo. We've got a crisis to deal with the coronavirus. It is of great frustration to me that this body, through its majority leader, through its other leadership, has known for years. I've put them on notice for years, for basically the entire time I've been in the United States Senate. I'm concerned about these provisions. I've made known ever since 2015, when we reauthorized these provisions at issue, that I would continue to want more reforms. Why we waited until the final days before the expiration of that period is beyond my ability to understand. But it is factually incorrect and manifestly unfair to suggest that I'm the one holding this hostage. It is quite the other way around, sir. As to the suggestion that these are FISA reforms, not Patriot Act reforms, well, yes, they're all part of this package that we refer to collectively as the Foreign Intelligence Surveillance Act. You're right. The provisions, especially the provision that I'm most concerned about, Section 215, as we call it, is Section 215 of the USA Patriot Act. I give him that one, but that doesn't address the substance of the problem here. As to Senator Burr's argument that we should err on the side of keeping Americans safe, I absolutely agree with that. No dispute there. I also agree with the findings of the Civil Liberties and Privacy Oversight Board that concluded a few years ago that our privacy and our security are not at odds with each other. This is not a zero-sum game between those two objectives. Our privacy is, in fact, part of our security. One of the reasons we became a nation, one of the reasons we don't fly the Union Jack or sing Hail to the Queen or wear wigs and robes in court has everything to do with the excessive abuse of the rights of English subjects, including those on this continent, while we were existing as British colonies. Our privacy and our security are not at odds with each other. They are, in fact, part of the same cohesive whole. Number six, the argument made by Senator Burr that this provides uncertainty for law enforcement. Well, let me tell you why that's the case. The only reason there's uncertainty for law enforcement on this, for our intelligence gathering and law enforcement agencies who handle this stuff, has everything to do with the fact that he just objected to this unanimous consent request. We could right now eliminate their uncertainty. We could likewise, at any point in the months leading up to this, at every point of which I would have been willing to debate and discuss these things, and I have had for years reforms on the table that we could have considered. We could have brought those up. We could have done it then. It is not me that is creating the uncertainty for law enforcement. It is instead the unreasonable objection to receive any of my offers, including passage of the Leahy-Lee bill, including passage of lone wolf and roving wiretap independently, including simply extending, cleanly reauthorizing the 3 expiring provisions for 45 days, giving us the chance to consider a handful of amendments. Now, don't talk to me about being the one who has created uncertainty. That, sir, is you. Number 8. Number 7, rather. Senator Burr argues that the President of the United States can do all of this in any event without the 3 expiring provisions on the books. Well, my response to that is, it's kind of curious. If that's the case, why are you fighting so hard for these provisions? Why should anyone be concerned about their expiration? You suggest somehow that we would not have guardrails, any guardrails in place, if in fact these were allowed to expire. If they were allowed to expire, I'm not familiar with any authority that would provide language identical to that found in Lone Wolf or Roving Wiretap or 215. So if that's the case, perhaps you, sir, would rather have them expire. I really don't know, and I don't think that advances your argument. Number 8, the suggestion was made that these amicus provisions, which are not the limit, they are one of 6 amendments that I would like to propose and that I'd like the Senate to consider, that the FISA court already has authority to appoint an amicus. Well, this is true. We put that in the USA Freedom Act in 2015. The court does have that authority. But that doesn't mean it happens as often as it should. And in fact, as we saw with the abuse that took place in connection with Operation Crossfire Hurricane, targeting the sitting President of the United States when he was a candidate. In many cases, the FISA court judges are not themselves terribly careful. Perhaps it'd be helpful to have somebody else in the room. I don't know why we should be so afraid of that. Number 9, to the extent anyone is going to let this program go dark, and if that concerns you, then you ought to agree to this unanimous consent request. This unanimous consent request will result in it not going dark. I've made it entirely foreseeable that I would want to have amendments at least debated, discussed, and considered before we got to this moment. It's not unreasonable for me to ask. I'm not asking that you accept these amendments, that you incorporate them into existing law. I am instead simply asking that we be given the opportunity to vote on them. Finally, number 10, Mr. Burr argues that this legislation was carefully crafted by the Attorney General, the Speaker of the House, and several other officials, and that some 270 or so members of the House of Representatives voted for this. Well, good for them. That is their prerogative. I have my own election certificate. I serve in a different legislative body. I'm aware of no obligation on my election certificate that requires me to defer to the Pelosi-Nadler-Schiff bill. In fact, I refuse to do that, Mr. President. It's insulting to this body. Had the Founding Fathers wanted to create a unicameral legislature, they could have done so. Had the Founding Fathers wished to create the Senate of the United States as simply a rubber stamp that would review what the House of Representatives did and then have a veto, yes or no, open or closed, a binary reaction to what the House of Representatives did, they could have and would have and should have done so. They did not. We have our own independent obligation to review this legislation. I have done so. I find it inadequate. And I'm not demanding that all my amendments be accepted as a condition precedent for my willingness to keep these from going dark. All I'm saying is that I want the opportunity to have amendments considered, bipartisan amendments introduced by several members. So I'm going to make another request. I'll tone this one down. I'll modify this one. Mr. President, I ask unanimous consent that the Senate proceed to the immediate consideration of the Senate bill at the desk providing for a 45-day extension of FISA. I ask unanimous consent that the bill be considered read a third time and passed, and that the motion to reconsider be considered, made, and laid upon the table. Further, that at a time to be determined by the Majority Leader in consultation with the Democratic Leader, the Senate proceed to the consideration of H.R. 6172, and that the only amendments in order be 5 amendments offered by the following senators: Senators Lee, Leahy, Daines, Wyden, and Paul. I further ask that upon disposition of the amendments, the bill be amended if amended, be read a third time, that the bill be that the bill as amended, if amended, be read a third time, and that the Senate vote on the bill as amended, if amended, with no intervening action or debate.
Is there objection?
I object.
Objections heard.
Mr. President, you may notice a pattern here. This pattern is going to continue. This pattern is going to continue because this is unjust. This is unrealistic. This is unsustainable. This used to be a body that prided itself on being the world's greatest deliberative legislative body. It's a body that has its own unique protections attached to it. Article 1 of the Constitution sets out the parameters of the Senate, and it makes clear that it'll consist of exactly 2 members representing each state. The one and only kind of constitutional amendment that is preemptively unconstitutional, that cannot be adopted, is that type of amendment that would undo this fundamental sacred principle of equal representation among and between the states in the Senate. You cannot do that. They did this with a distinct purpose in mind, that we'd have the ability to represent the states as states. We would not just be a roving commission on what was satisfactory or whether the House of Representatives had done its homework, but that we would be our own independent legislative body. We would be betraying our oath to the Constitution and those whom we represent if we didn't do this. This used to be a place for that very reason. In fact, until quite recently, it was a place where any senator could have any amendment considered on any legislation. Basic standards of collegiality, of decency, and respect for each other and for the rule of law itself convinced members over centuries, literally centuries, to defer to each other in at least their opportunity to propose and vote on amendments. In recent years, we've seen this deteriorated. We've seen it deteriorated, sadly, under the leadership of Republicans and Democrats alike. We've seen it deteriorate at the expense of the representation of each individual state. This simply isn't acceptable, that we would get to this point in legislation, we would be unable to vote on or consider basic amendments to so important a law. They're asking us to reauthorize these expiring provisions, provisions with profound implications not only for national security but also for privacy, which are part of the same cohesive whole. And they're asking us to reauthorize those until December of 2023, with only minimal reforms that I would add are modest at best, that are perhaps well-intentioned in some ways, but the Pelosi-Nadler-Schiff bill doesn't cut the mustard. It doesn't do the job. So I've just asked for 6 amendments. That was too many. And I've asked for 5 amendments, and that was too many. Surely they're not suggesting that we can't ask for any amendments, because if they did, that would be patently ridiculous. That would be uncollegial. That would be uncivil. It would be unsenatorial. So we'll try this again. We'll see what we can do with 4. Mr. President, I ask unanimous consent that the Senate proceed to immediate consideration of the Senate bill at the desk providing for a 45-day extension of FISA. I ask unanimous consent that the bill be considered read a third time and passed, and that the motion to reconsider be considered made and laid upon the table. Further, I ask that at a time to be determined by the Majority Leader, in consultation with the Democratic Leader, the Senate proceed to the consideration of H.R. 6172, and that the only amendments in order be 4 amendments offered by the following senators: Senators Lee, Leahy, Daines, Wyden, and Paul. I further ask that upon disposition of the amendments, the bill as amended, if amended, be read a third time, and that the Senate vote on the bill as amended, if amended, with no intervening action or debate.
Is there objection?
I object.
Objection heard.
Mr. President, this is the natural product of the American people being asked again and again to simply accept that this is how things will operate. The American people are told to just settle for budgets that don't balance or come anywhere close to it, to settle for a government that spies on you, that lies to you, that overreaches, and a legislative branch that's somehow all too content and seemingly eager and willing to allow and perpetuate and even expand those authorities. This is unacceptable. We shouldn't settle. We shouldn't settle for an overreaching government. We should expect a government that respects the letter and spirit of the Fourth Amendment. We shouldn't settle for a Senate in which the rights of individual senators, a bipartisan group of senators, has been trying for years to just have a vote on a few reasonable amendments, to be shut out. We should expect an open, robust debate, discussion, and amendment process. Don't settle for any of this. You should expect more. We should all expect freedom. We should all expect debate and liberty and the protection of your fundamental rights as American citizens. So we'll try this again. Rolling the number down to an absolute bare minimum number of 3 amendments. I ask unanimous consent that the Senate proceed to the immediate consideration of the Senate bill at the desk providing for a 45-day extension of FISA. I ask unanimous consent that the bill be considered read a third time and passed, and that the motion to reconsider be considered made and laid upon the table. Further, I ask that at a time to be determined by the Majority Leader in consultation with the Democratic Leader, the Senate proceed to the consideration of H.R. 6172 and that the only amendments in order be 3 amendments offered by the following senators: Senators Lee, Leahy, Daines, Wyden, and Paul. I further ask that upon disposition of the amendments, the bill as amended, if amended, be read a third time, and that the Senate vote on the bill as amended, if amended, with no intervening action or debate.
Is there objection?
Object.
Objection heard.
Mr. President, earlier today when the President of the United States issued a statement about the Pelosi-Nadler-Schiff bill, purporting to but utterly failing to meaningfully reform the 3 expiring foreign intelligence surveillance provisions at issue, the President expressed grave concern over the process. He expressed grave concern over the content of the Pelosi-Nadler-Schiff bill, which the Senate reviewed, voted on, passed without amendment, without adequate debate, violating the House of Representatives' own 72-hour rule in order to get there. Perhaps he was talking about that, or perhaps he was talking about the fact that the Pelosi-Nadler-Schiff bill really doesn't fix the problem. In fact, we look at the fact that there was overt, politically motivated targeting that took place against the President of the United States. Now, look, I know those were different provisions under Title I of the Foreign Intelligence Surveillance Act. I get that. But it's still part of the same legislative package. It's still part of the same set of laws that we're concerned about here. And the only time when we have the meaningful opportunity to take a deep breath and debate, discuss, and possibly amend these provisions is when they're set to expire. I referred earlier to the USA Freedom Act, which I authored and sponsored along with my distinguished friend and colleague, Senator Leahy, the senior senator from Vermont, back in 2015. That was brought about as a result of and during a moment when we were approaching the expiration of these very same provisions. That's how we bring about reforms. In fact, we brought about some reforms in that very legislation that were outside the narrow context of the 3 expiring provisions in question. There is no rule, no law etched in stone, written into the rules of the Senate, the Constitution, or anything else that tells us that we cannot, that we may not, that we should not edit or amend or reconsider any provision outside the narrow expiring provisions that we're facing with FISA. Quite to the contrary, we've got a pattern and practice in the past that has established that this is the way we do things. Now, look, in fairness, I wish we debated and discussed and amended these things a whole lot more, because these laws are really messed up. We ought to be reviewing them and updating them a lot more often. Not because the people implementing them are bad. Maybe some of them are. I don't know them. They've done some bad things, some of them. I'm sure there are a lot of people who have access to these tools, who are hardworking, well-intentioned, well-educated, and highly specialized. I'm even willing to assume most of them fit that description and wouldn't ever knowingly, intentionally violate that law. But the fact is, the law has been violated. There are very few instances that we actually know about. Why? Well, because this whole thing operates under the veil of secrecy. Sunlight illuminates and it also disinfects, Mr. President. And the opposite happens when a court charged with the sacred responsibility of determining and in some cases limiting the rights of the American people, U.S. citizens, operates in secret. I've devoted my career prior to coming to the Senate to litigation. I specialized primarily in appellate litigation and dispositive motions in federal court. One of the great things about the U.S. court system is the fact that despite its flaws, I'd put it up against any system of its kind anywhere in the world. And the reason is it's done with very, very few narrow, carefully cabined exceptions under the light of day. Rulings, decisions, judgments are made public, are subject to appeal, usually on multiple levels. It's not how the Foreign Intelligence Surveillance Court operates. It operates in secret. And so that's one of the reasons why we really ought to be reviewing and updating this stuff more often, especially when we know there have been abuses. We know from the sheer breadth of these statutes, some of which were written, by the way, in the immediate wake of the 9/11 terrorist attacks. Now, as I mentioned earlier, I was not then a member of this body. I was not a member of the Senate or the House of Representatives, where, in fact, I've never served over there. The Senate is the first place and only place I've ever held elected office. But I was an adult by then. I was a licensed practicing attorney by then. I remember watching as Congress was passing the Patriot Act, wondering why they were acting so quickly, so hastily, to put so many words and so many pages into a single bill. I remember wondering whether they might, in the process of doing that, trample over the fundamental rights guaranteed by the U.S. Constitution without the American people knowing it. This has come to fruition over time. We've seen that it has been abused. We know with a certainty, as sure as we know that the sun will come up tomorrow in the east, that this will continue to happen. Whether or to what extent it continues to happen or how long it's allowed to is in many respects up to us. As I said earlier, governments are run by human beings. Human beings, while redeemable, while generally good, are flawed, and they make mistakes. But they're much more prone to make mistakes when they can do so under cover of darkness, when they don't have to answer to anybody. That's what's going on here. That's why I'm so concerned about this one. And that's why I consider it so, I guess I'd say disappointed, Mr. President. It's disappointing that this body, some of the most talented people I've ever had the pleasure of working with, 100 members from 50 different states, each with his or her own story, with his or her own unique perspectives, that we should be asked to succumb to a process that doesn't allow us to have any input into a bill like this. In this case, it arose in connection with the Pelosi-Nadler-Schiff bill, a bill that I consider inadequate. It draws near to the Constitution with its lips, metaphorically speaking, but its heart is far from it. It pays loose homage to the notion that American citizens have rights worth protecting, and yet its provisions are malleable and easy to circumvent. It functions in much the same way as carbon monoxide might operate in the human bloodstream, where the human body might recognize something, mistaking it for oxygen. That, by the way, is, I'm told, why carbon monoxide is so deadly. Your body will tend to recognize it mistakenly for O2, and in some ways prefer it to O2, thus starving the body of actual oxygen. When we accept something that looks like it does the job, and it in fact doesn't, it can do a whole lot of harm in the process. Why? Well, because the American people and their elected representatives in the Senate and in the House and in the White House then have the opportunity to say, well, it looks like that was fixed. We can go on to look at something else. It's easy to do here because, after all, we've got no end of problems that we could be worrying about. Even if this problem disappeared and any 5 others that are at the top of the list, we'd still have thousands of others that we could worry about. That's exactly why it's such a problem. To have a bill like the Pelosi-Nadler-Schiff bill rammed down our throats and told that we've got to accept this, told that the President of the United States, who himself has had his rights violated, who himself was politically targeted under the FISA framework, it's insulting to every American that after something like that happens, we know it has happened, we know it continues to happen, we know it will continue to happen. To tell us that we've got to accept the Pelosi-Nadler-Schiff response to that is simply insulting. We shouldn't put up with it. President Trump sure shouldn't put up with it. The American people shouldn't. And it's not just Republicans, and it's not just Democrats. This is no respecter of persons or of political parties. In fact, many of my best allies on this issue are and have been Democrats. Democrats were pretty early to acknowledge the flaws in the Patriot Act and in provisions of FISA. Ever since I got here in 2011, I've been working across the aisle with Senator Leahy, with Senator Durbin, and with others to try to find solutions to these problems. One of the things that's happened in the intervening years, this is my 10th year in the Senate, is that this really has become a bipartisan issue. It used to be me and a handful of Democrats, and Senator Paul worried about this. We've now got a pretty broad coalition of Republicans and Democrats who are concerned about this. They're worried about it because if it can happen to the president, it can happen to anyone. The American people have been influenced in so many ways by our own history, and our own history extends back many centuries, not just on this continent, but back in the United Kingdom. Because, after all, it hasn't been that many years since we became our own country. We existed as colonies for almost the same period of time that we have existed as a free, independent, constitutional republic. In both sets of experiences, and in experiences even predating the American experiment in its entirety. We have seen that there are good reasons to require things like search warrants. When the government wants to get information from you, when it wants to search through your papers, your possessions, your personal effects, or when it wants to seize you or your possessions, the government really needs to get a warrant. It needs to establish probable cause supporting that warrant, and it needs to outline with particularity the things that it wants to search or seize. And it needs to do so from an independent magistrate. And all of these things matter. They matter not just because they're in the Fourth Amendment, not just because they were a good idea when they were put in there back in 1791, but because long before we became a country, these were part of the rights of English subjects, part of the rights that American colonists had as English subjects and that English subjects had even back in England. Now, they too had a government that was run by mere mortals. The divine right of kings notwithstanding, the monarch was also mortal, as were the persons occupying positions in Parliament and officers elsewhere in the government. That's why from time to time these rights would be abused. We saw instances of English patriots like John Wilkes, whose rights were violated and who sought legal recourse after he was subjected to unreasonable, warrantless, open-ended searches and seizures. John Wilkes became respected on both sides of the Atlantic because he didn't put up with it. Even though it cost him dearly in financial terms, socially, even politically, even though it caused him great pain, he aggressively litigated what had happened to him. And that's one of the reasons why he became a hero on both sides of the Atlantic. We look to heroes on both sides of the Atlantic, people like John Wilkes, who, notwithstanding the fact that he was an English subject, not an American, he understood the English Bill of Rights. He understood core rights that were incorporated as if by reference by the Fourth Amendment, but that were pre-existing long before then. In fact, things like the warrant requirement of the Fourth Amendment are rights that everyone should be entitled to in every country. It violates logic and reason and principles of decency and kindness to suggest that a person can be arrested or have his or her house or effects searched or seized without due process of law and without a validly issued warrant bearing particularity, backed up by probable cause. So what then does this have to do with FISA? Well, it has everything to do with FISA. It has a lot to do with it. The Foreign Intelligence Surveillance Act, as the name suggests, was created not to go after U.S. citizens, but to go after foreign spies and terrorists, not Americans. Sadly, over time, as a result of the advocacy of people who weren't all that afraid of big government, the advocacy and defense of people like Jim Comey and Robert Mueller, we got a sort of morphing of FISA into something that wasn't focused entirely, necessarily anymore, on foreign intelligence gathering, on agents of a foreign power, on terrorists, but could be used even with respect to U.S. citizens. This isn't right. In our hearts, we know it's not right. In our hearts, we should certainly know that it's not right when we've got the opportunity to consider some amendments. One of the amendments that I've proposed, and a key part of the Lee-Leahy reform, would provide something that I don't think would be shocking to any American citizen. In fact, I think any American citizen would be shocked not by the fact that it's being introduced, but by the fact that it's not already law. It would say that if they want to go after an American, if they know that the subject in question, that the target of their investigation is in fact an American, there ought to be added procedural protections attached to their investigation of that person. That if they get a court order under Section 215 allowing them to search for and gain access to any quote-unquote tangible things, any of the whole category of business records, they really ought to have to satisfy a different, slightly higher standard than they would if the person were a spy from a foreign country or a foreign terrorist or something like that. There are certain rights that do inhere in the fact that you're an American. That's not unreasonable. In fact, I'm not sure I know any American citizen outside of Washington, D.C., who would even have a moment's pause with that, other than to say, why on earth is that not already law? I'm also convinced that most Americans would respond to the beefed-up amicus curiae provisions. Remember, amicus curiae is a Latin term that just means friend of the court. It refers to the fact that within the Foreign Intelligence Surveillance Court, you have no jury, you have no opposing counsel, you don't have a court reporter that's going to report to anything in public. You instead have total secrecy. So our FISA provisions would expand, our amicus curiae provisions would expand the circumstances in which the FISA court must appoint a friend of the court, or amicus curiae, just to argue the other side. This part of it doesn't even really limit their power. It just says, let's bring somebody else into the room. Somebody else who can be trusted, who's got security clearance, but who can provide a different perspective. Most Americans, in fact, I'd say probably every American I know outside of Washington, D.C., would say there's nothing unreasonable about that. And in fact, what's unreasonable is the fact that that would require an amendment, a change to existing law. Another one of the provisions that we want to amend deals with what we call exculpatory evidence. The government should have a responsibility to disclose when applying for a court order from the FISA court under Section 215, to disclose evidence that would be exculpatory or that would show that the person being investigated might not have actually done the thing that they did, or that they might have flawed information on their hands. We know, Mr. President, that some of this has occurred where government agents have gone before the Foreign Intelligence Surveillance Court and failed to disclose meaningful, material facts that, if known, would have at least been material to the court and probably been determinative and resulted in the court's unwillingness to issue the order in question. I don't think I know anyone outside of this town who would say that that's unreasonable to request. Senators Paul and Wyden have a few other amendments, one dealing with limiting the government's ability through Section 215 to gain access to your browser history, another addressing the power of the Attorney General to make some of these approvals. Those are amendments that have been proposed by Senators Wyden and Daines. And then we have an amendment from Senator Paul that would propose that across the board, in all of the different provisions of the Foreign Intelligence Surveillance Act, whether it's 215 or 702 or Title I or some other provision, that if you're investigating a known American citizen, you've got a higher standard, and you probably need to go to a regular court rather than a secret Foreign Intelligence Surveillance Court that in most respects doesn't even meet the definition of court. Now, in response to some of these, opponents, defenders of the deep state, might well glibly conclude, well, there's no reason for you to impose a higher standard, for you to impose anything remotely resembling probable cause, because after all, in other contexts, the government can gain access to business records without showing probable cause. Well, while this is true in many circumstances, first of all, it ignores the fact that recent jurisprudence from the Supreme Court of the United States, including from the Carpenter case, makes clear that just because something is a business record maintained in the ordinary course of business doesn't mean the person to whom it pertains has no reasonable expectation of privacy in it. In some cases, it does. We're no longer dealing with the old jurisprudence of Smith versus Maryland, unadorned by more recent developments like Carpenter. Under Smith, they were dealing with the collection from a pen register, the collection of an old-style landline telephone that spat out the numbers that were called and being called to and from the line in question. Modern business records disclose a heck of a lot more personal detail than that. I suspect if Smith versus Maryland, the one dealing with the pen register and the landline telephone business records, if that were decided today, I think it might well have been decided very differently today than it would have been then. But certainly, with respect to many categories of business records, there is a reasonable expectation of privacy. There is some expectation of some privacy buried within that, and we can't conclude otherwise. Secondly, separate and apart from developments in the law that ought to cause us to view with some suspicion the government's open-ended ability with a mere subpoena to show relevance to and therefore access to certain categories of business records. Unlike those circumstances where someone could go into a regular court, whether in civil or in criminal proceedings, and get a subpoena based on a mere relevance standard without probable cause. In those circumstances, at least, there's more of an opportunity for somebody to respond. In many cases, that somebody might be the custodian of the records, the business entity in question, whether it's the mobile telephone services operator, the internet services provider, or the owner of the car rental facility, the storage unit facility, whatever it is. There's some opportunity for that business enterprise to go into court to try to quash the subpoena, to argue that the government doesn't, in fact, have a need for it, that it doesn't need to produce it, to defend its own business interests, if not those also of its own customers. And in some circumstances, there's also an opportunity for the person in question to be notified, independently to object to, or in other ways, one way or another, respond to the government's desire to gain access to those business records. By contrast, under the Foreign Intelligence Surveillance Court, you don't have that ability. That's why we need special protections here. Now look, it's not hard for the government to have to follow basic principles of due process. It's not hard for the government to have to show probable cause. In most circumstances, this can be done in a matter of minutes, and no one's ever demonstrated, to my satisfaction, why, especially where, as in the case of my probable cause amendment, the requirement that they satisfy that standard only when they're in the Foreign Intelligence Surveillance Court and they're going after a record pertaining to a known U.S. person. It would still allow them to go after other records pertaining to other people without that knowledge, and if they didn't know someone was a U.S. person, they wouldn't have to satisfy it. But even that is apparently unacceptable to the self-proclaimed masters of the universe who now dominate the United States Senate and refuse utterly to recognize the Article 6 mandated expectation and constitutional mandate of equal representation among the states in the Senate. This is unacceptable. We've reached a point where we don't have the expectation that we can rely on what comes out of committee, because very often what comes out of committee isn't even what's considered here. We had this Pelosi-Nadler-Schiff bill come out Tuesday night. It was passed the next day by the House of Representatives. Now, I understand why a simple majority of the House of Representatives might well decide to defer to Speaker Pelosi and Jerry Nadler and Adam Schiff. After all, Pelosi and Nadler and Schiff themselves run a very substantial portion of the Democratic Party's operations in the House of Representatives. I understand why a whole lot of members would like to defer to them. What I don't understand is why, number one, Republicans in the House of Representatives would also want to defer to Pelosi and Nadler and Schiff. Nor do I understand why, even if some Republicans in the House of Representatives would foolishly defer to Pelosi and Nadler and Schiff, why that in any way, shape, or form binds me or anyone else in this body to do what Pelosi, Nadler, and Schiff decided to do. We're not a rubber stamp. We're not a rubber stamp for the House of Representatives. We're certainly not a rubber stamp for the deep state. This gives me some hope, I suppose. Gives me some hope that, given the fact that the President of the United States is willing to acknowledge that FISA isn't perfect and that the Pelosi-Nadler-Schiff bill passed by the House of Representatives yesterday without having gone through any terribly thorough process, without members of the House of Representatives having had access to it for more than about 24 hours when they passed it. The fact that the President of the United States was willing openly, publicly, today, to call into question the wisdom of the Pelosi-Nadler-Schiff bill gives me some encouragement, Mr. President. Gives me some encouragement. One that some of my colleagues here in the United States Senate might see fit to claim the privileges attached to their election certificate, to recognize that we are not all just functionaries of our respective party leaders in the House and in the Senate, that we're answerable to our own constituents to defend the Constitution in the manner we deem appropriate and necessary under the circumstances. I expect that this body will do the right thing. I think it would be a shame, I think it is a shame, to let these three provisions expire and just let them hang out there with the uncertainty that Senator Burr so thoughtfully pointed out will be the product of these provisions expiring. We don't need to do that. We've had years and years and years to address this, and we have refused, we have deliberately declined, we have been recklessly indifferent with respect to the need to reform these provisions. If not us, who? If not now, when? I have no interest in continuing to pump this thing over and over and over again. This is like Charlie Brown going after that same football with the same Lucy, who moves the darn football every time he gets close to it. This isn't acceptable. No, I've got great confidence in my colleagues that a few of us, Republicans and Democrats alike, will come forward and say, no, not on my watch, not anymore. This is not how the Senate's going to operate. This is within just a few days of when we've seen a few other unfortunate things happen, things that are themselves symptoms of the same underlying problem. And I don't mean FISA specifically. I'm talking about something much broader than FISA. I'm talking about the deviation from the norms of courtesy that have come to define this body over the centuries. My friend and distinguished colleague from Louisiana, Senator Kennedy, had an amendment that he wanted considered and voted on last week in connection with the energy bill. Now, I disagreed with that amendment. I would have voted against it. In fact, I would have voted against it and spoken against it on the floor. I really didn't like it. But he had an amendment that he wanted considered. He was shut out unfairly, unreasonably. He was denied the opportunity to have that amendment considered. He wasn't even given notice, adequate notice, of his procedural rights that would come into play when the senator who had introduced an amendment, came down to the floor to amend her previous amendment and to use it as basically a manager's package, keeping Senator Kennedy's amendment out of that package, thus effectively denying him the opportunity to receive adequate consideration of his own amendment. He wasn't given notice. Because he wasn't given notice, he missed out on the opportunity to do what he inevitably could have done and would have done, so long as he could have come down here with 10 other senators, the combined total of 11 senators, sustaining him for his procedural right to call for the yeas and nays on the original amendment introduced by Senator Murkowski. We could have voted on that amendment, and she wouldn't have been able to insert that manager's package on her own without that intervening call for the yeas and nays on her original amendment. This is one of many examples that, while probably painfully boring to the average American, should be deeply disturbing to any American who knows about, who cares about, who yearns for the freedom that comes from a representative government, that expects that people elected to make laws will actually be participating in that process and not simply dictated to by two leaders, one Republican and one Democratic, in each House of Congress. Yet another manifestation of that, one that has sadly become sort of one installment in a many series, set of sequel movies, is what happens basically every time we have a spending bill. To cite one example that occurred nearly 2 years ago, we had for many months been waiting to see when we'd have the opportunity to debate, discuss, amend, and vote on a spending bill in the early months of 2018. It would be the first real spending bill that we had the opportunity to consider since the 45th President of the United States had been sworn in January of 2017. We had been told by our respective party leaders in both houses of Congress, wait for it, you'll get the chance to review it, you get the chance to debate it and amend it. And then one evening on a Wednesday in March of 2018, I received an email. It was 8:37 p.m. That email was from Republican leadership addressed to Republican senators saying, attached is a spending bill that we're going to be addressing. And I thought, good, this is what we've been waiting for months. We'll finally get to see it. I opened it up. It was 2,232 pages long. It spent, as I recall, $1.2 or $1.3 trillion. I immediately distributed it to members of my staff who worked through the night, splitting it up, figuring out what each provision meant, recognizing that a 2,232-page Senate appropriations bill doesn't read like a fast-paced novel. It doesn't read like a newspaper. It's a very slow and cumbersome process, one that involves countless cross-references to statutory provisions that wouldn't be recognizable to most ordinary Americans, so it takes a lot of time to review it. My staff, after working through the night and through the next day on it, was shocked, as I was, to see that the House of Representatives passed that bill, the same 2,232-page long bill that most members saw for the first time at 8:37 p.m. the previous night. The House of Representatives passed that bill before lunch the next day. The Senate, this body, convened in the middle of the night the following evening and passed it. Not one amendment, not one change, not from one member of this body. When we outsource things to the so-called four corners, the Republican and Democratic leader of each house of Congress, everybody else gets shut out. So, this might be really good for you if you're from one of those states represented by one of those four corners. It's really bad for everybody else. And I don't mean the members. I mean every single person represented by someone else other than those people. At the end of the day, Mr. President, it's not their fault. It's not the fault of the four corners so much as it's our fault. They're doing what they've got to do. They're doing the job the way they know how to do it, the way they've learned how to do it, the way we have trained them to do it, sadly enough. We let them do it that way, so they do. I'm sure it's not that it's easy to do it that way, but it's probably less hard than every other way out there. In that respect, I don't blame them for doing it that way. I blame us. Shame on us for passing that bill without any one of us having had the opportunity to read the whole darn thing, except for maybe four members, between 435 representatives and 100 senators. You maybe had four members total who knew what was in there and had control over it. Shame on us for passing it anyway, and shame on us if after the House of Representatives sees the Pelosi-Nadler-Schiff bill purporting to reform FISA while failing to actually do so in a meaningful way. After seeing it for the first time less than 24 hours before they vote on it, they pass it, shame on them. But if we pass it over here, shame on us. The shame is especially acute if we don't even try, which is what we're being asked to do here. We're being asked to defer, to let somebody else do the legislating. And by the way, just as we were told when approaching that spending bill and most other spending bills in the 9 years I've been here, that, you've got to leave this to the experts. Don't worry about that. That's for the Appropriations Committee chairman and subcommittee chairman, and for the majority and minority leaders from the two houses of Congress, and basically no one else. Leave it to the experts. Just as we were told then, leave it to the experts, now we're being told, leave it to the experts here. Which begs the question, what meaningful role do we play? Have we really rendered ourselves that insignificant that we're not even willing to defend our own right to raise our own ideas and our own concerns with something as profoundly significant and potentially impactful on the liberties of every single American, old and young, white and black, male and female, of any station, rich or poor? These provisions, make no mistake, have the potential to affect every single one of us. Shame on us if we don't even try to make it better. So I'm not going to blame this one on Pelosi, Nadler, and Schiff. They can choose to pass an unwise bill that doesn't fix the problem if they want to. But I don't work for Pelosi or Nadler or Schiff. I work for the people of Utah. I was elected by the voters in the sovereign state of Utah who expected me to come here and represent them. And this, by the way, is an issue that's neither liberal nor conservative. It's neither Democratic nor Republican. This is not a partisan issue. In fact, the amendments that I'm talking about here are bipartisan. This is simply an American issue. It's a constitutional issue. It's an issue pertaining to and inextricably intertwined with the basic dignity of the eternal human soul. We can't pass this thing while pretending to be concerned about the rights of the American people. Not at least unless we at least try to pretend like we're doing our job. Not unless we at least try to pretend like we're trying to make it better. Look, even if you don't think FISA has been abused, if you do, by the way, it's insanely, absurdly naive, but I respect your right to be wrong. I expect your right to agree with Pelosi and Nadler and Schiff on that front, if that's how you feel. But even if you feel that way, there have got to be other ways in which you might acknowledge you can make this bill better. Maybe you're somebody who trusts the government way too much. Maybe you are somebody who thinks the government ought to be given more power. Maybe you're somebody who wants the government, as long as they can make allegations that somebody is an agent of a foreign power or working for an agent of a foreign power or a terrorist or has had some unkind thoughts toward another person. Even if you trust government that much, you shouldn't, and what you'd be suggesting would be unconstitutional, but even if you were, then shame on you for not wanting to make this bill even more aggressive toward giving the government power. It is simply too grand a proposition to suggest that it's mere coincidence. The exact magical combination of factors, of provisions that should have been included in this law, in the minds of every member of the United States Senate, happened to materialize under the umbrella of the Pelosi-Nadler-Schiff bill passed by the House of Representatives yesterday. That's just absurd. I mean, come on. You telling me that you can't find a single provision that you think could have been written better? Some in that position still opposing it might say, well, yeah, but we've got other things to do. Well, that's true, which is exactly why I'm trying to provide 45 additional days for us to debate and discuss other issues first and then fix FISA later. And I'd be willing to cleanly reauthorize the 3 expiring provisions so that nobody has to deal with any uncertainty and the American people don't have to be put in jeopardy, neither their security nor their privacy, which are part of the same cohesive, continuous whole. Neither one of them has to be undermined. And yet that's what they insist that we do. So they insist that. So the argument might go, we've got other things to do. Well, if we've got other things to do, then let's punt this 45 days and let's just agree that we're going to vote on some things. But that's too much for them to suggest. To the extent they're arguing that we're too busy to do this right now, then I'd ask this question. Why? What are you doing right now? What better thing does any member of the United States Senate have to do right now at this moment at 4:54 p.m. than stand up and defend and debate the rights and the significance of the rights of the American people? I mean, I genuinely would like to know what is so compelling that makes it so we can't even debate these things right now. In fact, in the time that I've been speaking today, we could have easily voted on these very same amendments. We could have brought them up. We could have, and I would have agreed to limit our debate to only a few minutes apiece. As we saw during the impeachment trial a few weeks ago, we're actually capable of casting votes and completing them within 6, 7, 8 minutes if we stand at attention or sit at our seats and we listen as our names are called and then vote. So what I would ask is so compelling. Have people got an appointment for a haircut or a manicure, or do they have to go to the dog groomer? I really would like to know what's so compelling that makes it so we can't debate something as fundamental as how to improve the safety and privacy of the American people. I want to close by pointing out something that my friend and distinguished colleague, the senior senator from North Carolina, said a few minutes ago about the fact that he almost ensured that the program at issue, the program supported by the 3 expiring provisions, will go dark by objecting to my series of unanimous consent requests. And about the fact that as a result of his objection, not only is he essentially guaranteeing that these programs will now go dark, he's also guaranteeing that when we come back just a few days from now, because whatever it is that we've got to do in the next few days is apparently so important, which I really would like to know what that is. It's so important that we can't do this. When we come back next week, we're going to have to turn to this when we could have gotten that done today, instead of turning to other pressing issues in front of us, issues dealing with emergencies created by the coronavirus. We could have, should have, would have otherwise been able to turn to those things immediately. Instead, we'll be stuck on this for days. I mean, this can end up taking many days, a week or so, if it's drawn out sufficiently. The program goes dark, and we lose the opportunity to debate, discuss, and enact other legislation. All because we've got colleagues who decide that they know better. Not so much that they know better, but that Representatives Pelosi and Nadler and Schiff know better. It's their bill. Everybody else just voted for it. And now we're all asked to vote for it, and we're told to mind our own business, to butt out, because our big brother, brooding, omnipresent federal government knows better. It can be trusted. Trust Big Brother. Sure, he's going to spy on you, but his intentions are good. Sure, he's going to spy on you, but he's really just hoping to go after the bad guys. So you don't have to worry about the fact that he's spying on your neighbor, on your constituents, on innocent Americans. Even if I'm wrong, let's say for a minute that somehow I'm mistaken in concluding that any of this will ever be abused. You can't really get around the fact that it has been abused. We know of circumstances where it has been. We know that the President of the United States has himself been the target of abuse under this. But set that aside for a minute. Even under the absurd proposition that none of this will ever be abused again, and that Pelosi and Nadler and Schiff have somehow found the magical formula that will forever guarantee these expiring provisions from being abused again, why wouldn't you still want to make the bill better? Why would you be willing to let those provisions go dark? Why would you be willing to postpone the consideration of other pressing business before the United States Senate? Is it really that important to shut your opponents who happen to disagree with you out of debate? And what does this say for the next thing we consider, or the next thing after that? This, Mr. President, doesn't end well. We know it doesn't end well. It never, ever works to push U.S. senators to the point that they are told they're not entitled to their own opinions. And to the extent they have them, they may express them, but only in a brief period of time. Then they have to run off and be good little boys and girls and let the adults take over. No, no. I know that's the way it's been working for a while. It's not going to anymore. It's not going to anymore because the American people are demanding more. They're demanding better. Things sometimes have to get a little worse before they get better. That's unfortunately the position in which we now find ourselves. They've gotten worse, but they've gotten worse in a way that the American people are now noticing, and they're going to say, don't do this anymore. Don't lock us out of the process. Don't tell us we don't matter. Don't tell us that our own elected senators can't have a voice and that they won't get a vote and that they cannot debate it. Madam President, the President of the United States has been targeted unethically, unlawfully, unscrupulously by the deep state. We have the opportunity to fix that, to make sure that doesn't happen to this president, any future president, or any U.S. citizen, regardless of how rich or poor or powerful or powerless. We must fix it. Shame on all of us if we don't. Our oath to uphold, protect, and defend the Constitution of the United States requires more than this. The American people deserve more. They deserve better, and we must provide it. Thank you, Madam President.